Hey guys, come on in. Join me in this live session. We're going to talk today, this afternoon, about the question, can I come back into the United States if I leave for an embassy interview? Okay? Can I come back in if I leave for an embassy interview? Let's talk about that immigration issue today. And as you come on board, guys, as you come on board, friends, just share with me who is watching and where you're watching me from. It's so nice to be with you guys today in this session. I see that a few of you are coming on. Excellent, excellent. Good to see you guys. Comment below. Hey there, Samantha. Thank you so much for being with me this afternoon. So nice to always see you. And be sure to share this live session with your feed friends. Give me some hearts, likes, and stars. You're watching me on Facebook, so it's all about the stars these days, right? Thank you so much. Hey there, Roland from Wyoming. Thank you so much for being with me. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide and in many different countries to help solve tough immigration problems that our clients are in. And we do this work. We start off with a consultation. Reach out to us at McBeanLaw.com or at 516-866-3900 to request an appointment with us. Hey there, Linda. Thank you so much. Misty, thank you. Cynthia, nice to be with you today. Cynthia is in Jamaica. Hi there, Laverne. Always great to see you as well. Also, friends, if you're catching the replay on YouTube, go ahead and subscribe to the channel and hit that notification bell so that you'll also be the first to get notice of these videos each week. I see folks are on from India and Bahamas. Hey there, Chuckles. Chuckles from Bahamas is joining. Friends, we have a terrific firm newsletter. And if you're not getting our newsletter, you should get our newsletter. Subscribe at McBeanLaw.com so that you could get our weekly updates and some other good stuff. Hey there, Jenny. So let's talk about this issue, friends, about leaving the United States and being able to come back in. Okay, I'm going to just have like a little heart-to-heart. I have no further meetings this day, and so I want to take a few minutes and talk with you heart-to-heart about this issue that comes up very frequently in the work that we do here at McBean Law and with our clients. Can you come back in to the United States if you leave? Okay? Can you come back in? You're here, you've overstayed your visa, and you're going through an immigration process, and you've been told that in order for you to get your green card, you actually need to leave and go back to an embassy for an interview. But that terrifies you because you think, well, if I left, am I going to be able to come back in? I have my family here, I have my job here, I have my life here, I have my future here. Why would I take that risk and leave all of that behind me? Will I be able to come back in? I have a lot invested in being in America. If you've had those concerns, friends, let me know in the comments below. I'm not going to put it up here on the screen, but just let me know that you can identify with this, okay? This issue of needing to get your green card, but the only way to get it is by leaving. Okay, so, and also share this session again with your feed so that more people will be able to see this video and be helped by it. Now, you can come back to the United States, guys, if you're approved of the visa, obviously. You leave and you have a successful embassy interview and you get that immigrant visa. Under those circumstances, obviously, you can come back in and get your green card in the mail. You could also come back in if you had left with advanced parole, which is a travel document that tells you that during a certain period of time, you can leave the United States and come back in. Okay, so if you're here and you have temporary protected status, for example, or even DACA, and you leave the US, or you've even applied for a green card here, but you leave the US and you have that travel document, it allows you to come back in. All right, so those are the obvious two ways that you could come back in. But this process that I'm describing today applies to people who cannot adjust their status in the United States. They cannot get through here because maybe they've overstayed their visa, or they had entered the United States without lawful admission. And so our government doesn't allow them to get the green card here. Congress set this up, guys, in such a way that you'd have to leave. Okay? You'd have to leave the US and finish the process abroad. But you cannot leave the US knowing that you're not gonna, there might be a possibility that you don't come back. You want to have that assurance that you could come back in. And so I'm going to talk with you about how you could have that assurance that you could actually come back into the United States if you were to leave for an embassy interview. Well, firstly, the folks who I'm describing in this situation will need a certain waiver to be approved before they leave America. They need that waiver to be approved to deal with the issue of their overstay, their unlawful presence. They need that waiver. So if they have a certain relative to obtain that waiver and the waiver is approved, then they can leave. But what if that person has other issues in their background? Okay, if there are other issues in their background, this is when it becomes very important to ensure that you have a complete and thorough background check on yourself before you leave America. You need to have an awareness of what immigration is going to look at, the embassy or the consulate official is going to look at when they're examining you. And so the background check should consider a few things. Firstly, it should consider whether you have a criminal history, whether you have an arrest history, a conviction history, and if so, what is that history and how does that history impact immigration? That's one thing to think about, the criminal past, if there is one. If there's no criminal past, the next thing I want you to think about is, do I have immigration violations on my record that they're going to be concerned about? And if so, what are those violations? We've already talked about unlawful presence, okay? What else could they be concerned about? Well, they could be concerned about other things related to whether you've ever committed fraud or misrepresentation, things like that, right? Have you ever lied on any paperwork to immigration that you've submitted? Have you ever omitted something that immigration found to be important along the way? They're concerned about those kinds of things. Have you ever falsely claimed to be a U.S. citizen? If you don't have those issues analyzed carefully before you leave America, it can be a significant problem when you're out of America at an embassy and you're now learning about this thing that, oh God, I wish I had known about that when I was back in Brooklyn, when I was back in Newark, New Jersey, or, Mount Vernon, wherever. I wish I had known about that before I stepped foot at a U.S. embassy abroad. You want to know about these things before you leave. So have your case, your background looked at very, very thoroughly to ensure that you're protected and covered and all bases are covered before you leave America. All right. And so the worst case scenario for anyone is they leave and they cannot come back permanently. That's the worst case scenario. The second to worst is you leave and then you learn about something new at a U.S. embassy, and then it keeps you out for a lengthy period of time until that issue is resolved. You don't want any of those things to happen. So get your case looked at very carefully, your background, before you leave the U.S. The other thing to think about is the fact that some other issues concern U.S. embassies. For instance, do you owe the U.S. government any money? Do you owe any hospitals here any money? Have you paid your certain debt, right? Particularly if the taxpayer dollars have been involved in that situation. They care about that too. Okay, so make sure those kinds of debt are cleared up before you leave the United States. Then the other thing is this, and this goes back to the issues I was speaking about regarding those immigration violations. Certain immigration violations can only be cured, guys, once you leave America and you go for your embassy interview. Okay? Once you leave and you go for that embassy interview and they bring it up as a problem, and then they tell you you're going to need a waiver. These are my notes for this live session. You're going to need a waiver to address this problem. Go and file that waiver, and then, after we get your approval, we could take it from there. Some people need this other waiver prepared at the end of the process for them, and at the end of the process for them, it is that embassy interview. And so you go to your embassy interview knowing that you're going to need that second waiver to address that other immigration problem or whatever it is, criminal record, whatever that problem is, and you need a waiver for it. You go there with that awareness and you're prepared knowing I'm going to be back in my country for a certain period of time until the waiver is approved. Now, the thing with these waivers, guys, they're not that easy to get approved. They're very complicated. They really are. And they really look for you to have a parent or spouse, U.S. citizen or green card holder. And they look to see whether that individual will suffer very extreme hardship, not just regular things like high blood pressure, diabetes, things that are related to obesity and stuff like that. They're looking for very, very serious issues. And it just doesn't always have to be a health issue. We've been able to help clients who didn't even have health issues. They're looking at a totality of issues that could be going on with your parent or your spouse, U.S. citizen or green card holder. And you have to be able to argue that they will really suffer if you are deported and sent back home, and because they need you here in America with them. That's really the basis of, that's what you're arguing. And so the waivers are not easy to accomplish. And so if you know that you're going to an embassy interview, you're leaving the United States for an embassy interview, and you're going to need a second waiver at the end of that interview, you've got to make sure you have a strong case so that you can win that waiver. And chances are, if you won that first waiver dealing with your unlawful presence in America, most likely you're going to win the second one too, okay? Because it's going to be very similar. Now, do not be afraid of the idea of leaving. If you follow some of the tips that I've shared with you in this one about background check, ensuring that all bases are covered, you will be fine. And for some people, this is the only way that you could get a green card, as Congress had set this up, okay? Congress set this up. So if you're out there and you're pondering this question about, well, if I were to move forward with my waiver case, am I going to come back to America? It is possible to come back to America if you have a good case and you have that winning waiver. It's possible, all right? So that's what I wanted to share with you today. That's what I wanted to share with you on this short one. And I see some of our clients are watching. Hi there. Hi there, Betty. Good to see you. Thank you, Wael. My apologies. I'm just scrolling through just real briefly to see if there's anything here that I could answer for you guys. Priority date, someone is asking about that. But before I answer a few questions, I also wanted to let you guys know that our office hours are Monday through Friday, 9 a.m. to 6 p.m. Eastern time. That's when you can reach us to schedule an appointment with one of us so that we could talk about your immigration case, okay? When we talk about priority dates, this is a question that Angie has. Angie, priority date is simply the date when the government received your file, okay? It's the date, it's when they received it and you got in line for your green card. You got in line, okay? And priority date is very important for people, particularly who are in the family preference category, F1, F2, F3, F4, right? As well as those in the employment-based categories. And it tells you where the government has reached in terms of that long line that people are on for that green card, okay? And so they will not adjudicate your case until you reach that point, that date. So that's really how I like to describe it. I hope that was helpful to you. Okay, let's see. What else do you guys have to say? You're so quiet. You're quiet this afternoon. Let's see. Okay, I like this question. It's about TPS and asylum. So Mr. Steven is asking, says, I have TPS, temporary protected status, and an asylum case in court. Friends, you know that you could have multiple things going on with immigration at the same time. So he has TPS, so he can work lawfully with his work permit, and if he is granted advanced parole, travel document, he can travel on it and come back in. And we've helped a lot of people in that situation. So he has an asylum case pending in immigration court, removal proceedings. Can he travel with the parole? You can travel with the parole and come back. Now, what I don't know about your case in court is whether a removal order has been issued, because even if one has been issued, you can use your advanced parole to come back into the United States, and we've seen that happen successfully for other clients as well. So, but obviously we always tell immigrants, if you're an immigrant in America without a green card, at a minimum, you're always traveling at your own risk. But with the advanced parole, you can leave the United States and come back in. Now, I don't know if you had lawful admission to begin with when you first came into the United States. If you did not, and now you're going to use your advanced parole to leave and come back in, it will give you that lawful admission that you would need for adjustment of status to get the green card here. Now, deeper the issue is who will then have jurisdiction over your green card application. All right, so work with an immigration attorney if you're looking to go to the finish line, okay, to the finish line. I hope that was helpful. Okay, let's see what, I hope you guys don't mind me pulling your question up here on the screen for others. You guys know this is the culture. This is how it's done with online immigration Q&As. So Ms. Smith says her aunt has been here over 30 years unlawfully, no criminal record. Can we help? So she has assets. Can the system help? Okay, so she will be treated like everyone else, right? Whether she has been here for over 30 years or whether she was here for a year. The analysis is always the same. We will look to see if she's eligible for a green card under the family-based system, and if so, what would then be the next? Who would be the petitioner, and how long will her wait be? And can she get the green card here in the U.S., or will she need to finish the process abroad, as I've discussed in this video, through the waiver process and some other things? So she can reach out to us. We're going to look to see what does she have in terms of petitioners. Does she have a spouse, U.S. citizen or green card holder? Does she have a parent who is here, U.S. citizen or green card holder parent who can start the process for her? Does she have adult U.S. citizen children, 21 or over? I don't like looking at siblings because she's been here in the United States for over 30 years. A sibling cannot help her cross the finish line, so I would never consider a sibling process for her. And I would not consider the only way I would consider an employment process for someone in her shoes is if she had a spouse or parent, U.S. citizen or green card holder, who could help her with a waiver that she will need to be successful. And then she'll have to finish the process overseas. We can also look at whether she fits into any of the humanitarian options. Had she been married to a U.S. citizen or a green card holder who abused her? Does she have any adult U.S. citizen children who abused her? Has she been a victim of a crime here in the U.S., a certain kind of crime? What kind of crime? Does it rise to the level that immigration cares about? We would look at that. Has she had a very, very bad experience with an employer who really mistreated her in a very bad way? I sound like Donald Trump when the brain stops thinking, it uses words like bad in a very bad way. Very bad, bad. So you guys get the point though, right? That we would drill down to see what happened with the employment, to see whether it rises to a level for a certain visa that's available to individuals who have experienced some labor violations. So those are the areas that I would inquire into, guys, for someone who's been here for over 30 years. I would even wonder, is she in removal? What has she done along the way with immigration? Is her record clean? I know you mentioned no criminal record, but is there anything else there that would stand in her way, such as falsely claiming to be a U.S. citizen, right? Or the permanent bar, is that something that is her problem? Guys, sometimes when you see folks who have been in the United States for many, many, many years and they cannot get through, there are these very serious immigration walls that they can't get through. All right. So I would look to see if she's facing one of those serious walls or not. And if there's an opportunity, we would be very, very happy to help her. Hello. You pop up quite frequently, sir. It's nice to see you. Nice to see you. Thank you so much for joining this afternoon. Let's see. Maureen is asking for our phone number. Well, I don't need to send it to you, right? Because it's on the screen and I'm going to share it with you now. It's 516-866-3900. So reach out to us to schedule a meeting with us, okay? All right, Betty. Hi there, Betty. Betty says, why is it so hard to get a visitor's visa if you are married and filing for yourself? So I've done videos on, I did a recent video on visitor's visa and some things that you should really think about if you've been refused of that visitor's visa. So go back and watch that, Betty. It's on McBean Immigration TV, and it's also on my Facebook page as well. Normally it's a little easier if you're married, just so you know, it's just a little easier to be approved for the visitor's visa when you have those kinds of ties. But it's all about your intent and whether you're planning on going back home or not, and you've got to convince the embassy officer with certain evidence, that you're going to come back home because you have your family ties back home, you have your employment back home, you have your assets back home, you don't have any intention of staying in the United States permanently. You have responsibilities that you've got to get back home. Watch that video. I go into a little bit more details. It was a video from last week. And Mohammed is asking, do we help with U visas? We do U visas as well. U visa, guys, is for crime victims. And I really, really love when we get those kinds of cases. They're so rewarding to help victims of crime. And oftentimes victims of crime who are immigrants, they don't like to work with law enforcement. They're afraid to work with law enforcement. And so for some of them, they miss out on an opportunity to obtain lawful status in the United States. But if you can get through that pain and trauma of what you've experienced and you're ready to work with law enforcement on it, think also about the immigration side of it too, because you could if it's a certain kind of crime, not all crimes work for this, but if it's a certain kind of crime, you can do a U visa. Takes forever though, not the greatest processing case in terms of timeline. It takes a long time, several years, but once you get that breakthrough, you really get that breakthrough. So yes, we do those cases, and we really like to get those kinds of cases. So reach out to us, okay? We do EB3 with the employer. We need the employer for that. So if your employer wants to file for you and you're here in a lawful status, then contact us. The employer, we want the employer to contact us so that we could start talking with them about whether they're eligible to petition for you as and what the job offer is and such. We do those. Get on Attorney Bobis, Leah Bobis's calendar for that kind of discussion on the employment side. Yeah, the unlawful presence waiver processing time has gone up for everybody. It is true. It is very frustrating to wait on that one. Okay, Arden is asking, if I apply for asylum and I didn't win the case and I'm deported, can I get a waiver to come back legally? So with, if you're, I don't know how far your asylum case has gone, whether you were recently placed in removal proceedings, don't know, or whether the judge has already made a decision and you're fighting it, you're appealing it, or where are you in your timeline? But wherever you are in this timeline with asylum, or whether it's at USCIS, it might not even be in court yet, I don't know. But if this is just generally speaking for folks who are deported, there are some ways of coming back into the United States early if you're eligible for it. Okay, there's a waiver that some people are eligible for, and we work on that process as well. But your case, your full background, what happened in court, what type of, really what happened in court, what type of asylum case did you have? What did the judge consider it frivolous? Did you just file this and wasted all of these resources in court and frivolous, right? Is it that level? Is it that bad? If it's that bad, you're barred, okay? It's a very serious thing to file a frivolous asylum application if a judge determines it to be so. So we would have to look at the record carefully to see what was said in court, what did you do, or didn't do, what your lawyer didn't do. We would look at all of that to determine whether you can come back. For anyone, whether it's asylum or anyone who has been deported from the United States. Let's see what else is in the hopper. I don't know what Winifred is saying, that she's from Sierra Leone. And she entered with the F1 student visa, but I applied after I was denied. Say my husband was to invite me. Can I apply again? I'm not sure, honestly, if you're outside of the United States or whether you're here. Maybe you could reframe the question again slightly differently for me. Where's the 8 years coming from? Tell me what this 8 years is in your reframing, okay? Diane, I don't know what kind of case this is. Stephen will do a consultation. Good. Some of the questions, what you've written is cut off a little bit. Can my Gordon is asked, Hyacinth is asking, can my unemployed green card holder son file for his 8-year-old in Jamaica. Yes, he can do that. He can file for the 8-year-old in Jamaica. He will just need, so when he files in the beginning, his income is not going to be that big important. Maybe by the time the case reaches the National Visa Center level, the NVC Hyacinth, then at that point he will need to submit an affidavit of support showing that he has enough income to file for his son. If he doesn't have enough income, meet that threshold, then he could always get a joint sponsor, and that sponsor's income should be enough to bring the son here. Okay, folks are asking for my number, my office number, but it's in the video. It's scrolling. Just read read through. Is credit a requirement to file for your spouse? I honestly don't understand what that means. Is credit a requirement? What do you mean by credit? Asylum seeker since 2017, no interview. Yeah, Trump turned asylum really upside down, guys. The people are waiting a long time for an interview. Then you have some people who recently filed and they're getting through faster than others who were waiting way back when, 2017. What you can do in a case like that is you have to think about whether you have any basis to seek an expedite of your case. What's really going on here? Is someone else at home in your home country connected to you, like a child, a spouse, whose life is also in danger, and they're on your filing? You know, what's going on? Why is there such an urgency? And if you have a reason for that, sir, then you should seek an expedite through the asylum office in your city. Seek the expedite, and if you get that expedite approved, you've got to be ready. You've got to be ready with a good case to go in for your interview, okay? Because if they approve the expedite request, the interview follows very quickly. So although they give you a little period of time to supplement the record, to submit more to them, but you've got to be ready to act very quickly. So there's that, okay? Okay, all right, so I'm gonna jump off. Answer this one last question, okay? Answer this one last question. If you get the extension to your extension on your conditional green card, which is the 2-year green card, can you go ahead and apply for citizenship? So what this person is asking is that, she got married, her spouse filed for her, and they were married less than 2 years when her case was approved, so the government gave her a 2-year green card. After which, towards the end of that 2-year, she and her spouse, I'm assuming it's joint filing, I don't know, could have been by yourself as a waiver, but they jointly applied for the 10-year. At that point, the government is doing these automatic extensions, okay? The automatic extension happened. And so she's asking, well, can I just go ahead now and apply for citizenship even though my 10-year petition is still pending? And the answer is yes, if you reach 3 years of residency. 3 years of residency, okay? And so if you've hit 3 years of residency, you can apply for naturalization, and it can be pending along with your 10-year green card petition, okay? And so best case scenario is that you get approved for naturalization, and then there you have it, it's over. Now it's 3 years for her, because she's going to be seeking citizenship through marriage. If she wasn't seeking citizenship based on the marriage, she would have to wait 5 years. And guys, I will tell you this, that strategically for some people it makes sense to wait until the 5-year mark, despite the fact that they had gotten their green card through the spouse. It makes sense if the marriage isn't going so well in those early days, and you don't want the government to really inquire into your marriage when you apply for citizenship, right? And so you wait until your 5-year mark, and then they don't have any reason or business to question you about your marriage. So strategically, for some people, it makes sense to wait until 5 years so that you're treated like everyone else who apply for naturalization. But if you have a good marriage, things are going well, you have no concerns about it, then do it at the 3-year mark of residency, not marriage. Whew. So I'm gonna go now. Guys, it was so delightful having this Q&A with you. If you'd like more of these types of sessions, let me know below in the comments. I will read the comments tonight. I will read those comments, let me know below, and I will be happy to get back with you in a similar fashion. You guys are the best, and be sure to share this session with your feed, and contact us at 516-866-3900 for an appointment with us. See you guys soon. Have a great evening. Bye-bye.